Hello, everyone. Thank you for joining me here today. We're talking about what the Social Security Administration looks at when trying to evaluate whether a trust is a resource. So, the question you might be having yourself having right now, other than how do I get MCLE credit, which is why I'm leaving it on this screen for a second, is who is this Francesco guy? Why do I care what this guy has to say? So I'll tell you a little bit about myself, just so you have some insight as to why, what I think might matter. First off, just to be clear, I'm a lawyer, not a cat. I can't see if you're laughing, but I will assume you are. I'm a prior attorney at Social Security Administration's Office of General Counsel. I worked out of the San Francisco office for a majority of my 10-year career there, but I also spent a couple years in the Chicago region. And while I was an attorney there, I worked on designing and establishing a new business process in Region 9 for the review of trusts and evaluating whether or not trusts are a resource. I had oversight into training and overseeing the review of trusts for the Office of General Counsel for Region 9. And Region 9 covered the states of California, Arizona, Nevada, Hawaii, as well as a few small territories that aren't even worth mentioning because nobody lives there. It does trust probably. But Guam would be one of them, the Mariana Islands. I trained other OGC attorneys. That's relevant because those are the attorneys who are now reviewing trusts for Region 9. And those of you who are dealing with trusts in different area of the country, the next thing I talk about is going to be less applicable to you because the processes haven't really changed outside of Region 9 yet. Maybe Region 9 will be kind of a pilot that other regions adopt, but for the time being, Region 9 is the only one who's involved with, what's that, did I say? Yes, a new business process, a process that involves the review of trusts for whether or not they're a resource. And that's primarily how the process has changed. So to understand what the process is, first I'll talk about the old process, and then I'll discuss what the new process is in Region 9. So the old process, and the process that's primarily used throughout the country currently, is that claims representatives at the field offices receive the trust, they review the trust documents, and then they do their best to try and figure out whether or not the trust is a resource. Primarily, they'll use the Program Operations Manual System, or POMS, which is Internal Agency Guidance, to evaluate whether or not the trust is a resource. Now, the problem is claims representatives, most of them don't see trusts too often. I mean, most of them are doing a lot of other things, including working on disability cases, documenting those cases, and doing lots of different other tests. So occasionally they'll get a trust. And then, at first they'll be shocked by it, and then they'll wonder, what did I do the last time I saw a trust? And then they'll try to remember, and the whole process might take a few weeks for them just to kind of calibrate into what they're doing. That was causing an issue for both the claims representatives who had lots of different work, and it was causing an issue for the supervisors and the district offices, because they understood this was a big time crunch. A lot of time was being invested for claims reps because they didn't see the trust often enough to become very familiar with them, and they weren't attorneys. So some of the wording or the terms used in the trust, they weren't very familiar with. So what would often happen is then they had a regional trust review team, which was basically a bunch of other claim representatives, but those that were detailed to the team, who became more familiar with trusts by trainings and then just dealing with them more often, who could then provide guidance to the claims representatives. And with oversight over that regional trust review team was the regional trust leads. These were a few individuals in the Center for Disability and Program Support in the regional office who would field more of the high-level questions and sometimes submit questions to the Office of General Counsel for a formal legal opinion. Some of these formal legal opinions would then end up in the Program Operations Manual system under the Precedent Opinions tab, which would then in itself become policy. So what is the new process in Region 9? Well, claims representatives and the Regional Trust Review Team working in collaboration with them, when they become aware of a trust, they will develop the evidence. So they'll make sure that they have source of funding. They'll make sure that they get all the documents associated with the trust, funding documents, if there's any other trusts out there that the trust is related to, schedule of assets, hopefully, but usually they'd leave those out half the time. And then, if it's a pooled trust, they get joinder agreements, master trust, anything else like that. So then they submit that to the Office of General Counsel. And so the attorneys at OGC in Region 9 would then evaluate whether or not the trust is a accountable resource. So this is important because, once OGC makes a determination, is a trust accountable resource, then the claims representatives can use that information using the POMs to evaluate whether income or whether distributions from the trust are countable income. And countable income and countable resources are both important for determining whether a trust is whether a trust or resources are going to make somebody ineligible for SSI. So what does all this mean in terms of practical what's going on? Well, trust evaluations are now typically in Region 9 anyway, being done by attorneys. That's good generally for people that are submitting these trusts because the attorneys are going to be more sophisticated in their knowledge of the law. They're going to see these trusts on a more regular basis. So just a few attorneys at OGC will be focused on this work and have been focused on this work. And so the more trusts they see, the more familiar they are with the issues and the better of an evaluation and outcome you're going to see with the agency reviewing this. Better for somebody who's familiar with trusts and the law to be looking at trusts than a claims representative who has no legal background and only rarely saw a trust. So the claims representatives will then get the guidance from OGC and render a determination on the trust. Likely, it's going to be a determination that closely adopts the guidance from OGC. But a common problem is the agency, upon getting the guidance from OGC, the regional trust leads puts this information into a system, data system, which the agency likes to use, called the SSI TMS system. And that information is basically typed in, and then the claims representative has access to it and would use that information in providing a determination. Now, if a claims representative finds a trust as accountable resource, then they ought to be issuing a manual notice of denial. And this manual notice of denial ought to cite the problematic portions of the trust and the policy that the trust is violating. Now, in terms of the violation of the trust, they would be copying down what basically OGC likely said. That said, if if they don't fully understand the guidance, then that might not translate well into the manual notice. So that means some of this might be lost in translation. OGC attorneys might provide pretty solid guidance, but maybe not all of that information is then inserted into the manual notice of denial. And if that happens, best case scenario, you're not going to have a ton of information explaining why your trust was counted as a resource, and you're going to have to seek reconsideration. So you're going to have to appeal because, probably they're not going to know where they lost that information at. So they're not going to give you a new notice of determination until you seek appeal and ask for reconsideration. And then you'll get hopefully a better notice if they were to deny you again. So why is it important whether or not a trust is a resource? Well, as I mentioned, this will obviously be important in evaluating whether or not an individual exceeds the resource limits for SSI. And if they do exceed the resource limits, then even if they are disabled, they won't be eligible, disabled and or, of retirement age, they wouldn't be able to get SSI because of those resources. So what generally are the things the trust or the SSA is looking at when they're trying to evaluate whether or not a trust is a resource? Well, probably the most, I'd say the initial thing we're looking at the outset is who funded the trust. So is it a first party or third party trust? Is it a mixed trust? So a combination of the two. And if it is a first party trust, does it qualify for an exception to resource counting? So that generally, we're going to get into all of that, but that's kind of the things we're looking at. And then in terms of the exceptions, there's two main types: the special needs trust, 1917 D4A, or the pooled trust exception, 1917 D4C. So who funded the trust? That's one of the main issues and one of the threshold issues SSA is looking at when they're trying to figure out whether or not a trust is a countable resource. Who funded the trust will dictate what policy is applied. If the trust is funded with the assets of the beneficiary, then generally speaking, the agency is going to apply this law of 42 USC 1382B, also known as the Social Security Act, Section 1613E, which is summarized somewhat in POMS SI 01120.201. So if it's self-settled trust, a trust established with the assets of the beneficiary, this is the policy they will apply. And the policy is applicable in regards to that portion of the self-settled trust that could be paid to the beneficiary. So even if the beneficiary, even if the trust is irrevocable and the beneficiary doesn't have direct access to the fund assets, it's in a discretionary trust, so only the trustee decides how to make distributions, the beneficiary under this policy would have a countable resource equal to the amount of the trust that could be paid to the beneficiary. Okay, and then in a third-party trust situation, the trust is funded with the assets of a third party. And so 42 USC 1382 BE does not apply. And then how would you evaluate whether a third-party trust is a countable resource? Well, that's in POMS SI 01120.200 subsection D, which essentially provides that the principal in a trust that is a third-party funded trust is not a resource so long as the beneficiary does not have power to terminate the trust and then use the funds for his or her own food and shelter, and they don't have the power to direct use of trust principal for his or her own support and maintenance. Or, this is also important that the beneficiary not be able to sell his or her interest in the trust. That's why sometimes we'll see spendthrift provisions being important, because if it's a quantifiable distribution and the beneficiary can sell that, that would be considered essentially having some control over the trust property, and that portion that could be sold would be accountable resource. Now, the agency does have issues in determining the value of that amount in certain non-spendthrift trust situations. And I've noticed that they seem to avoid the situation where they can, which is to say that even sometimes when there's not a spendthrift provision, the agency might avoid even doing this analysis because it's hard to determine what could be sold in terms of the beneficiary's interest, who it could be sold to. So how do you quantify that, and what's it worth in determining whether or not the beneficiary has a resource? So I put together some examples we could go through in evaluating kind of the situation where we're trying to see who funded the trust. Was it the beneficiary or was it somebody else? Because this analysis isn't very simple a lot of the time, and it can be very complicated both for the agency and for the drafter of the trust to determine who really owns these assets. So the key point is that who owns it at the time they're transferred into the trust. So that is the time we care about. Somebody owned it 10 years ago and then they didn't, and then later on it got transferred into the trust. Well, we care about right at the time of transfer. So in a somewhat classic scenario, Aunt Betty establishes a trust for her nephew using her own money. Her brother, she appoints as the trustee. The nephew has no power over termination or distributions and cannot otherwise direct distributions. Well, is this a first party or third party trust? Well, I think this is a pretty classic example of a third party trust. It's Aunt Betty's money. She put it in there. She can trace it to her bank account probably, and it's probably not going to be in dispute that it's her money if there's no evidence that it was originating from the nephew. Also, the nephew doesn't have power over this money, not the trustee, not in charge of distributions. So in this regard, it's a third-party trust, and under POMS SI 011-20-200 subsection D, it's also not going to be an accountable resource. In a different scenario, but somewhat similar, Aunt Betty establishes a trust for herself. She appoints her brother as the trustee, and upon her death, the nephew will receive a 50% distribution of the remaining trust assets outright. So that means a check cut directly to the beneficiary upon Aunt Betty's death. So Aunt Betty dies, but instead of an outright distribution, the brother, who's the trustee, sees that the nephew has special needs, and so he petitions the court to modify Aunt Betty's Aunt Betty's trust to distribute the nephew's share to a new trust called the nephew's trust. Okay, so the nephew's trust will hold that money for nephew. Nephew won't have access to it. The brother will be the trustee of that trust as well. And so, like I said, the nephew won't have access to that trust corpus or to direct distributions. So in this scenario, who is this? Is the nephew's trust that's newly created, is that a third party or self-settled trust? And is it accountable resource? Well, it's a self-settled trust, and the key question is whether or not the beneficiary. I can see some of you are raising your hands here. So what I would advise is maybe to write down these questions, whatever questions you have, and I know we'll have to circle back around to it, but write down the questions, and then at the end when we do the Q&A, we can come back and circle back to the questions and hopefully get you an answer. But because we're doing this for the CLE, and a recording, might be helpful to kind of get through the initial presentation, and then we'll get it back around to the questions. But going back to the example, so the key question is, was the nephew entitled to his share of Aunt Betty's trust at the time it was transferred to the nephew's trust? So Aunt Betty died. So that's 1.1 in the timeline. After she died, the nephew became entitled to his share outright. So when the brother trustee didn't pay it to the nephew, he was acting correctly, looking out for the welfare of the beneficiary there. And he petitioned the court and got the court's approval to create the nephew's trust and fund it with his share of Aunt Betty's trust. But at the time the court funded the nephew's trust with his share of Aunt Betty's trust, at that point in time, those funds were considered the assets of the nephew, because even though he didn't actually receive the funds yet, upon Aunt Betty's death, he was entitled to them. So he had legal right to them. So if you look at POMS SI 1120-201 subsection B1, the definition of an asset is property, or it's a resource, any resource, but also property to which the individual is entitled, but that does not receive or have access to because of an action by the individual or his spouse, or by the action of a person or entity, including a court, acting at the request of or on behalf of that individual. So in this scenario, the court is looking out for the best interest of, and the trustee is acting on behalf of the interest of the beneficiary, the nephew, and the nephew did not receive or have access to the funds upon Aunt Betty's death. But nevertheless, these were payments he was entitled to. And that's key in saying that now the nephew's trust is a self-settled trust. And so the trust is a resource unless an exception applies, which we'll get into later. So this is an MCLE code. I'll leave up for a few seconds.
Okay, and Paco, I'm going to break in for just a minute. Just a little reminder here, because here is that this is accredited for MCLE credit by the North Bay Housing Coalition. So for those of you that are taking this for credit, and this is in California, here, once again, there's going to be 3 codes. This is the first of the codes, which is code number 1 is 8820. Here we do have an MCLE form that you need to download. But if you haven't downloaded it already, once again, just write down the 3 codes, and you're going to need that to get your credit. And that should be good for attorneys and fiduciaries. Okay, so anyway, Paco, were you a little more honest, dude?
Thanks, Steve. Okay, so continuing on with the presentation here. The next example in looking at whether a trust is self-settled or a third-party trust, here's a situation I'd see pretty commonly when I worked at the agency, which is, Joe's father establishes a UMTA account, so Uniform Gift to Minors Act account for Joe when Joe was a child. And then later on, Joe's father decides, well, let's not leave the money in this UMTA account. Instead, let's transfer that money to a special needs trust or a trust for Joe. So under the Uniform Gifts to Minors Act in most states, Joe won't have access to the account funds until he reaches an age of majority. So let's say his father transfers the UTMA account funds to a trust when Joe's 16. And then let's say Joe's father is the trustee and Joe doesn't have any power to terminate a trust or direct distributions. Okay, so Joe's father's transferred the assets from the UTMA account to this trust The way the trust is set up, if it's a third-party trust, it's not going to be a accountable resource. But if it's a self-settled trust, it would be. So who owns the assets or the funds in the UTMA at the time of transfer? So the quick answer is that Joe does. Obviously Joe doesn't have access to those funds yet, but under POMS SI 01120.205, the agency considers the transfer of the UMTA or Uniform Gift to Minors Act funds transfer to be an irrevocable transfer from the donor to the minor. And so the minor is technically the legal owner as far as the agency is concerned at the time of transfer to the trust. So this is kind of even though the money in the UTMA account wasn't a resource under agency policy, it was still a payment or money to which the Joe was entitled. So this is a little bit different from a qualified tuition program like a 529 college savings account. The agency would not typically consider the funds in a 529 college account the assets of the one who is going to be going to college because that minor doesn't retain legal ownership. And the donor does, and the donor can make withdrawals from those funds. Okay, and yet another example, we have a situation that comes up quite often, believe it or not, that a parent collects gifts for a child or somebody for a period of time, and then says, oh, this is quite a bit of money. Let me put this into a special needs trust or trust for, in this case, Sue, so that she has access to these funds or doesn't have access to them, and we can create a situation where it's not an accountable resource. But let's say the parents in this situation have collected gifts to Sue for several years. And then when she's 10 years old, that's when they transfer it into a trust. So who's the owner of the funds when it's deposited in the trust? Well, I mean, the intent of the family members was to give the money to Sue, but the parents have been holding on to this money for a long time, maybe even have been holding on to it in their bank account under their name. So the agency is really going to be wanting to see where this money came from. If they see a direct transfer from a bank account that has the parent's name on it, then there's a high likelihood the agency is going to say that this is a third-party trust. On the other hand, if there's a statement, especially a statement done on a SSA 795, when asked about the source of funding, if the parents say, well, this is Sue's money, we've merely been holding it for her, that could raise an issue where the agency sees the source of funds to be Sue's funds, and thus we have a self-settled trust. Obviously, the evidence here is not going to be great either way in terms of establishing the source of funds. Been a lot of years where maybe cash was just held for Sue. So the best evidence might end up being a statement from the parents saying, who does this belong to? And the agency would probably just have to take the parent's word on it because there might not be any other evidence. Also, generally speaking, the agency is supposed to, even though it's not always the case, is to, unless they have reason to doubt what you're saying in one of these statements, to kind of credit those statements, especially in situations where the source of funds isn't won't be easily identifiable through documentary evidence. And then one last example, let's say we have a situation where Roger's father lists Roger as the beneficiary of a life insurance policy. And then Roger's parents established a trust for Roger. And the schedule of assets identifies the life insurance policy as an asset that's been transferred to the trust. But then Roger's father dies, and then Roger's mother seeks to deposit the proceeds from the life insurance payout into Roger's trust. So obviously she's thinking this is money that's designated to the trust. And so, directly upon receiving that money on Roger's behalf, she puts it in the trust. So is this a third party or self-settled trust? Well, the problem is that the life insurance policy agreement listed Roger as the beneficiary. The agency is most likely going to interpret this then as the proceeds of the life insurance policy belonging to Roger. So if the mother puts Roger's the money Roger was entitled to receive from the life insurance policy into the trust, that portion of the trust would be considered most likely by the agency to be self-settled. So, when a trust is established is also really important, not just who establishes it with what funds, but when it's established. And obviously, the farther we get away from January 1st, 2000, the more time that's elapsed since then, the less applicable this will be. But for those self-settled trusts that have been established prior to January 1st, 2000, the agency won't apply 1382BE. Instead, they'll apply regular resource counting rules. So POMS SI 01120 200 subsection D, applying to third-party trusts, would also apply to self-settled trusts established prior to January 1st, 2000, which is that trust would only be a countable resource if the beneficiary has power to terminate the trust and then use those funds, or to direct distributions for his or her own support and maintenance. So what's it mean for the trust to be established prior to January 1st, 2000? Well, it's not enough that the trust agreement's executed, but the trust has to at least have some funding in it prior to January 1st, 2000. So if the trust has some funding prior to January 1st, 2000, then if there's additional funds added to the trust after January 1st, 2000, then that trust will still get to avoid Section 1382BE, which is the trust would still be evaluated the same as a third-party trust, so long as there's some funding of the trust prior to January 1st, 2000. So what does the agency do when a trust has some assets that were transferred that belong to the beneficiary and some assets from a third party? Well, they try to trace the source of the funds as best they can, and then any interest accrued on those funds while in the trust, they attribute to tracing back to the original funds and where those came from. So a trust might have two aspects. There might be a portion of it that's evaluated by the agency as a third-party trust, and a portion of the trust that's evaluated as a self-settled trust. And maybe it'll be that part of that trust is a countable resource and part of that trust is not. Okay, so let's assume a trust is a self-settled trust. What are the exceptions? So how do we get around that, or how does the agency look as to whether or not somebody successfully met an exception to resource counting? Well, there's two types of exceptions. There's the special needs trust exception under 1917 D4A and the pool trust exception under 1917 D4C, and we'll talk about both and the specific requirements for both, although there is some overlap. So a special needs trust, to meet the exception to resource counting, which is to say to not be counted as a resource despite being a self-settled trust established after January 1st, 2000. The beneficiary must be under 65 years old and must be disabled. So technically, the trust won't suddenly become a countable resource if it was established when somebody was under 65, and then they turn 65, all of a sudden it is an accountable resource. But if there is any additional funding in the trust after the individual turns 65, that portion of the trust that is funded after the individual turned 65 would not meet the exception. So that portion of the trust would be accountable resource, most likely. Okay, so in addition to being under 65 years old and disabled, the trust must be established for the sole benefit of the beneficiary. Now, this sole benefit, this idea of sole benefit is very important. It comes up in a lot of ways when the agency is looking at whether or not the trust is accountable resource or meets an exception, that is. And it's not technically in the Act. So it's not technically under 1917 D4A, but the agencies definitely read it that way. And you know, to the extent that the trust provides some benefit to another person, you have to be very careful. And we'll go into some of those scenarios soon. And then the who can establish it. So special needs trusts prior to December 13th, 2016 could not be established by the beneficiary. And we'll get into that more, but it could be after December 13th, 2016, and on that day, the beneficiary could establish a special needs trust for him or herself that meets the requirements in 1917 D4A. Also, the beneficiary's parents, a legal guardian, a court could establish it. And then finally, to meet the special needs trust exception, there must be certain Medicaid payback language. And that's a hot topic that often gets trusts disqualified from the exception. So we'll discuss that as well. So starting first with the Medicaid payback language. Okay, so probably by far the number one, I've reviewed hundreds of trusts when I was at the agency, and by far the number one issue for why a trust did not meet the exception was because the trust restricted Medicaid payback to one state or two states, or maybe just the states where the beneficiary had lived. The agency will find this to be a violation. The trust must provide for reimbursement to any state, so keyword being any, that provides Medicaid to the beneficiary during his or her lifetime. So this means you can't restrict it to California alone. You can't restrict it to just the states the beneficiary has lived. It has to be any states. It has to clearly state that the beneficiary receives Medicaid, medical assistance under a state Medicaid plan. And also the language can't limit the time frame. So there can't be a limit on the time frame where the state or states can obtain reimbursement, and there can't be a limitation on the time frame in which the beneficiary received the Medicaid. So you can't say, well, so Medicaid payback upon the beneficiary's death, for Medicaid he received between the ages of 18 and 35, or the state can receive Medicaid payback upon the beneficiary's death so long as they file a claim within a year. So those would be violations. Also, it's important that the Medicaid payback language is consistent throughout the trust. In theory, regular trust interpretation would provide that, you know, you look at the settler's intent, you read the trust as a whole. But what often is the case is the agency is going to identify one place in the trust. Let's say you do it right 4 times, but one place you have it where it looks like you've restricted the language to Medicaid reimbursement to California, and you did that because you had Medi-Cal requirements in mind. The agency will cite that and say, you know, even though you did it right 4 times, this language is too restrictive and the trust doesn't meet an exception to resource counting. So consistency is important. So here are some examples of problematic language. One would be, let's say, upon the beneficiary's death, the trustee shall reimburse the state of California for medical assistance the beneficiary received under Medi-Cal. Okay, you know, this actually happens a lot. this language would be found to not meet an exception to resource counting. The agency would then find most likely that whatever trust this was in was a countable resource. Another example would be upon the beneficiary's death, the trustee shall reimburse the states so this language is generally okay. But then it says, so reimbursement as of the date of the execution of the trust agreement. So it would look that this provision is limiting the amount of reimbursement to the states as to only equating to the amount of Medicaid paid to the beneficiary after the execution of the trust agreement. This would not be okay with the agency. They want to see that there's just a general requirement to pay back the states for Medicaid, no restriction in time like this. So what would I advise? What do I think the agency wants to see? Track the language in POMS SI 01120.203 subsection B10 closely. A lot of the good trusts that I've seen that meets the agency's requirements has this language. It's okay to put this S in parentheticals. So upon the death of the individual, the states will receive all amounts remaining in the trust up to the amount equal to the total amount of medical assistance paid on behalf of the individual under the state's Medicaid plans. Obviously, this is really broad language, but they kind of like that. The agency likes seeing that in the Medicaid payback area. And then, make sure that the states are listed as the first payees. It's nice to say as first payee or priority reimbursement. If there is excellent Medicaid payback language or Medicaid reimbursement language, and then there's also some other reimbursements going on, maybe distributions to third parties, and it's not really clear what the order is, even though the trust might set it out in a kind of a chronological order as to what the distribution would be, but doesn't really clearly identify what distribution comes first upon the trust termination, then that's going to be problematic. The agency, in some instances, might say, okay, it's pretty clear from the order that the Medicaid is going to be paid first, but it's better just to clearly identify that other than permissible administrative expenses, the states will be the first payees. And so what are the two permissible expenses that could be paid prior to this Medicaid payback? Well, it's very limited. It's state or federal taxes due from the trust because of the beneficiary's death. These are not inheritance taxes that the residual beneficiaries would have to pay. This is just state or federal taxes due from the trust directly for the beneficiary's death. And then reasonable fees for administration associated with the termination and wrapping up of the trust. Don't provide for payment of debts owed to third parties prior to Medicaid payback. It's okay if you provide for these as long as they happen after Medicaid payback. Don't provide for funeral expenses, which is probably the most common violation I see in terms of pre-Medicaid payback expenses that violate the agency's policy. And then payment to residual beneficiaries. Don't have any payments to remainder beneficiaries prior to Medicaid payback. And lastly, last illness expenses. Well, technically speaking, there might be a situation where these would be okay if there were expenses provided for under the trust that accrued while the beneficiary was still alive, and then it was just a matter of making the payment, which was part of the wrapping up of the trust estate. In theory, this would be okay. I would say it's better to stay away from this because this could be seen as payment to a third party made prior to Medicaid reimbursement if you set out last illness expenses specifically in the termination provisions of the trust. So I would just say be cautious. Don't provide for last illness expenses if you can avoid it. And then so getting back to the sole benefit requirement, One of the most common violations of this idea that the special needs trust has to be specifically for the sole benefit of the disabled beneficiary is termination of the trust during the beneficiary's lifetime, and then what happens then. So under POMS SI 01120 .199 subsection E, if the trust terminates during the beneficiary's lifetime, after Medicaid payback to the states and any permissible administrative expenses, the remainder of the trust balance would have to be distributed to or for the benefit of the beneficiary. Now, this POM section actually recently changed because it used to be that the section provided specifically for distribution directly to the beneficiary after Medicaid payback and permissible expenses. But now the provision says that it's okay for the distribution to be to or for the benefit of the beneficiary, which indicates in my mind that the agency is being a little bit more open-minded in terms of the fact that perhaps early termination won't necessarily need to result in a direct check to the beneficiary, but perhaps could have something else in mind as long as it clearly sets out that the funds would be used or to the beneficiary. So what's an example? Here's some examples of problematic language. So after Medicaid payback and any permissible administrative expenses, the trust provides that upon early termination, the beneficiary's family will receive the amount that's left in the trust. And sometimes I've seen that this language is pretty common, and then it's backed up with language that the family should then use the funds to care for the beneficiary. The problem here is that at this point, once the family gets the funds, the trust is terminated. So the family at that point doesn't really have any obligations under the trust because the trust no longer exists. And if the family wants to blow the money on themselves and not for the beneficiary, nobody's really stood there to stop them. So this language, isn't really that useful. The agency is just going to interpret this as a distribution to somebody other than the beneficiary. So don't provide in the event of early termination for distribution to the family, even though the family is supposed to take care of the beneficiary, okay? And then another example is some trusts just say distribute the remaining trust funds as if the beneficiary died. Well, that's not going to be any good because typically that's just going to result in there being a remainder beneficiary that gets the money, and that's going to violate the sole benefit requirement. So don't provide, I'd say don't be lazy when you draft the trust and just say, okay, well, we don't have to worry about this. What happens in the event of early termination, we'll just distribute it the same way as if the beneficiary died. No, it needs to be a little bit different because typically distributing it as if the beneficiary died will often result in a violation of the sole benefit provision. Okay, how are we doing on time? Okay. So some other problematic situations is open-ended, not real clear what happens to the remaining trust assets if the trust were to terminate during the beneficiary's lifetime. Sometimes there might be language indicating the trustee or a court has power to terminate the trust during the beneficiary's lifetime, but doesn't specify how the corpus would be distributed in the event of such a termination. The agency is typically going to just assume the termination on death provisions apply. And again, those most likely will result in a violation of the sole benefit because that money wouldn't be going to the beneficiary.
Okay, and this is our second code here. So, that's code number 1. Well, we'll make our second code 6681, even if that is a repeat of the number. So code number 2 is 6681. Okay. Paco, shall we continue on?
Sure. So what are some other violations of the sole benefit requirement? So it used to be that there was a major issue the agency was having with language that there would be expenses or distributions to companions. Companions being for just improvement of the quality of life of the beneficiary. But the agency was concerned that distributions to a companion were violating the sole benefit requirement because somebody, some third party person, was receiving money and really potentially not in practice providing any benefit to the beneficiary. Maybe even a family member who was just, there somewhat. So, so in some portions of the special needs trust, there's a definition of what are the special needs distributions that can be made by the trustee. In this section, I generally advise, and for purposes of the agency's review of whether the trust is an accountable resource, that less is more. The more things you list, probably the more likely, and the more specific you are in that regard, probably the more likely the agencies to say, oh, that specific expense, that could be used improperly to just benefit a third party without benefiting the beneficiary. We're going to count the trust as a resource. We're going to find it doesn't meet an exception. So generally, I would say, as a general rule, less is more. That's probably a good way to go. There has been some development with this idea of companions, and POMS SIO 1120-201, subsection F3 now provides that payment to third parties are not necessarily a violation if the primary benefit is for the beneficiary. This is really what I would consider open-mindedness by the agency. Came out a few years back to really say, we're not going to just blanket say that a distribution to a third party violates the exception to resource counting. We're going to be open-minded and really kind of consider how that payment is, is it primarily for the benefit of this beneficiary? Not can it just simply be in practice misapplied, but on paper, is it for the benefit of the beneficiary? And that's something too. When the agency looks at this trust, there's a tendency to think about that, for them to think about how somebody could, take advantage of the language to make improper payments. And that really shouldn't be part of the analysis, but it oftentimes is. So it's important that the wording of the trust is set out in a way that, if it can be helped, to avoid possible misapplications. And that was a big problem with the companion payments before, is they saw it in practice as giving trustees an opportunity to just give money to some third parties without really the beneficiary deriving any benefit. So one holdover, though, is this third-party travel expense. You have to be careful, especially in that section where I mentioned that your trust might identify specific distributions. If it's providing for distributions for a travel companion or a third-party travel person, make sure you read POMS SI 01120.201 subsection F3, B, and C very closely, because there's very specific provisions on how that distribution would have to be made. Not just in practice, but this should be in the trust itself, because you don't want to leave it too broad and then the agency find there's a violation in what can be paid for a travel expense to a third party. So if the third party is accompanying the beneficiary, that must be necessary for the beneficiary to travel. And if the third party is coming to see the beneficiary, it must be for the purpose of overseeing the beneficiary's living arrangements, or for an advisor, successor, or a fiduciary to ensure the well-being of the beneficiary. So I mentioned this before. Who can establish a trust? Special needs trust under 1917 D4A. Well, prior to December 13, 2016, a beneficiary couldn't be executing the agreement establishing the trust for him or herself. Now, distinguish this from who's funding the trust. Well, the beneficiary obviously can fund the trust, but he can't be the one executing the trust agreement. Also, a parent, grandparent, legal guardian, or court could establish the trust. When the court is establishing the trust, it might be that the court issues an order that uses the wording that it is merely approving or granting somebody's petition for establishment of the trust. The agency would now consider the trust to be establishing, the court would be establishing the trust even with this approving or granting language, so long as the trust did not exist prior to the court order. If a trust is around for a while and then somebody petitions the court to kind of affirm its existence, at that point, the agency might find that, most likely would find that the trust was not established by the court because it was already in existence. So pooled trusts, like special needs trusts, must have this Medicaid payback language, can't be restricted to reimbursement of any particular states, must be for all, provide for any state that provided medical assistance to the beneficiary under a state Medicaid plan. And the trust could be established, unlike special needs trusts under 1917 D4A, pooled trust could be established, or a pooled trust account could be established by a beneficiary, through execution of the joinder agreement, even on their own behalf, prior to December 13, 2016, and of course after December 13, 2016 as well. So what are some unique issues that you might see in a pooled trust that you wouldn't see in a special needs trust scenario? Well, trust or remainder share issues, management by nonprofit organizations, early terminations, and then have trust modifications between the master trust and the joinder work, and we'll talk about each of these. So a trust remainder share. So the unique thing about pooled trust is upon the death of a beneficiary, the trustee can retain a certain percentage of the trust balance or the trust account balance prior to making a Medicaid reimbursement to the state. So the trust could provide even that the trust retains 100% remainder share prior to any Medicaid reimbursement to the states. And then, but something that's very important is that the pooled trust clearly established that the trust remainder share does not apply in the event of early termination. So even though the trust upon the beneficiary's death can retain a remainder share, that is not the case if the beneficiary if the trust account were to terminate during the beneficiary's lifetime. In that event, after a Medicaid reimbursement to the states and permissible administrative expenses, then the distribution of the remaining trust account would have to be to or for the benefit of the beneficiary. Also, probably one of the hottest topics right now for the agency, at least in terms of the formal opinions, is the management by a nonprofit. The ME POMS SI 01120.225, which kind of sets out kind of this policy, is a bit conflicting. On the one hand, it allows delegation to for-profit so long as the nonprofit maintains ultimate managerial control. Okay, that's fine. So the pooled trust has to be established by a nonprofit, and they have to retain ultimate managerial control. Well, what will often happen is then the trust will be specific in terms of what kind of delegations can be made to another organization and perhaps even a for-profit organization. And the biggest issues happen in that fine reading of does the nonprofit maintain ultimate managerial control? But POMS SI 01120.225 also provides examples of activities that a nonprofit must be responsible for. And it goes beyond just maintaining ultimate managerial control. It includes stuff like, and this is a non-exhaustive list, determining the amount of the trust corpus to invest, removing or replacing trustees, and making day-to-day decisions regarding the health and well-being of beneficiaries. To me, that last one particularly, or even the first one, determining the amount of trust corpus to invest, doesn't seem like it's a major ultimate managerial control issue, but really a day-to-day operations issue. So even though on the one hand, the agency is saying you can delegate to a for-profit for day-to-day operations, then they're saying essentially that you cannot in another section. And that can be problematic for nonprofits who don't have the resources or the manpower to do all the activities they need to do. They need to delegate some of that to a for-profit company. And so this can arise as an issue. And there's no real solution here I'm going to be able to figure out for you, but it's just something to keep in mind. And it's an issue it's becoming more and more in the spotlight for the agency. So it's more and more likely to become a problem for pooled trusts. So then in terms of early termination problems, so a trust can most likely, the master trust and or joinder agreement has provisions for the trust terminating in two ways. And sometimes I've seen that when the trust account is terminated during the beneficiary's lifetime, the language might be acceptable to the agency, but then there also might be a provision in the trust agreement that provides for what happens when the master trust itself, for whatever reason, can't carry on. And I've seen then that language not comply with POMS SI 01120.199 dealing with early termination provisions, ensuring that either A, what's left in the trust account holder's account would have to be distributed to the beneficiaries, or B, it would have to be distributed to another qualifying special needs trust. And since we're at the time limit here, I'll try to move a little bit quicker so we have plenty of time for questions and answers. So just remember when you're modifying the pooled trust, take into account the joinders. Every sub account of the trust for a beneficiary is going to have a joinder typically. And so if you modify the master trust, how does that affect the sub account? Well, the joinder might set out that the master trust, any modification to the master trust has those modifications apply automatically to the joinder. That's probably best. And if it doesn't, the agency might interpret a joinder that's executed prior to the trust modification does not apply to that sub account. So then the sub account joinder would have to be re-executed. So that's really important in situations where the master trust was found to be not a countable resource. And so the master trust was modified to comply with 1917 D4C. How is that joinder or that sub account now complying? Is it complying? Well, the agency is going to look at when the joinder was executed in relation to the modification of the master trust. So it's probably best if you have a provision in your joinder providing that any subsequent modification of the master trust applies to the joinder. So here, this is a really important point I just want to cover. So let's say your trust meets an exception to resource counting. So it meets 1917A, D4A, or D4C. Okay, great. But the analysis doesn't stop there. The agency will then apply the same analysis that applies to a third-party trust. So this follows, okay, a trust meets an exception, but that doesn't mean necessarily it's not a countable resource. So after it meets the exception, the agency is going to say, look at, okay, is the trust a countable resource? So can the beneficiary terminate the trust and distribute the trust assets for its own support and maintenance, or otherwise direct distribution of the trust property for the beneficiary's own support and maintenance? Can the beneficiary do this? And does the beneficiary have power over the trust in this way under POMS SI 1120-200 subsection D? And this is important, very important. One of the things the agency looks at, even if the trust is expressly irrevocable and doesn't give power to the beneficiary to direct trust distributions. For most states, if the trust, if it's a self-settled trust and the beneficiary is the sole beneficiary, so he's the settler and sole beneficiary, then the agency will find that the trust is revocable by the beneficiary as a settler and sole beneficiary if there's no remainder beneficiaries. So it's important to identify at death, of the beneficiary that there is some remainder beneficiary. might even be the heirs or heirs at law in California. That is an identifiable class of beneficiaries. But it's important that there is some remainder beneficiaries, or else the agency is most likely going to find that the trust is revocable, is a revocable self-settled trust, and thus is accountable resource, even if it meets an exception to resource counting under 1917 D4A or C. So really quick, what do you do? So the trust finds your trust is accountable resource. What do you do? Well, you can amend the trust, and some people often ask, well, isn't there a 90-day amendment period? And technically, the application of this 90-day amendment period is very limited. As a beginning point, the trust would have to have previously been determined by the agency to meet the exception, not the accountable resource. And then later they find out or decide that it is. And then in that situation, they give you 90 days to amend the trust without any suspension or benefits. And even then, it's only in 4 scenarios. When there's problematic early termination language, third-party travel expense problematic language, pooled trust problematic management provision, or a null and void clause. And the whole reason why they have this 90-day amendment period is because the agency basically flip-flopped on their policy at one point, and they wanted to give people an opportunity to, be able to modify their trust without, necessarily suffering the consequences. So the 90-day amendment period can apply, but it's relatively limited. When it does apply, the clock begins when the agency gives notice. It might not always be formal notice, so you have to be careful. And then what should you do if the agency finds your trust as accountable resource? Well, I think, and I'm a litigator, generally speaking, is that you appeal. You appeal, and then you appeal. So first, seek reconsideration. That's not likely to change the outcome. They're going to be applying the same policy, and probably it's going to be the same people looking at the trust. Secondly, request a hearing before an administrative law judge. This might change the outcome. Administrative law judge is likely to follow agency policy, but they might have a completely different interpretation, and they don't deal with trust that often, so they might be doing their own research or asking for a formal legal opinion. Then if that's an unfavorable decision, request a review by the appeals council. Again, this is unlikely to change the outcome of the ALJ's outcome, but you need to do this in order to get to the next stage, which is appealing to the district court. And appeal to the district court, because the outcome of the district court is likely to be very different. The district court is not bound by POMS and the agency's interpretation of the statute. And the statute is very broad. And the court's probably going to be looking at the intent of the settler, which is to comply with the statute, and reading the whole trust as a whole and giving probably some leniency to the intent. Now, too, I think that especially in California, the judges are going to be very reasonable in terms of attempts by the individual who drafted the trust and the beneficiary and the trustee to comply with the agency's rules. Most of the time, people are trying to comply, and it's just the agency isn't always being too clear on what they want. So, the district court's going to take that into account. I advise appealing to the district court all the way up to the district court whenever possible, even if you amend the trust. Still appeal for those prior months or years of benefits that might otherwise be taken away, because when you get the court judgment, ultimately the agency is going to have to reverse that finding and either pay back those benefits or squash the overpayment or what have you. And so I'm not going to get really into the miscellaneous because we're running out of time. I would just say, these are specific issues. Nunc pro tunc doesn't work. The agency won't recognize a retroactive court order of amendment. Right of withdrawal, be very careful. If you allow beneficiaries to withdraw funds within a certain amount of time after the contribution, agency might find those contributions to be accountable resource up to the amount that could be withdrawn, either for that period or potentially indefinitely. And then the transfer penalty doesn't apply to special needs trusts that qualify under 1917 D4A. So you don't have to worry about that in a special needs trust scenario. where it does meet the exception to resource counting under 1917 D4A. Okay, and that's
Okay, and then for our code number three is 9801. That is 9801. That will be our last code, and I think we're good with time.
okay.
We have 35 questions, and that doesn't include the chat. I've got a sneaky suspicion we're not going to get through them all, but we're going through a lot of them here. So for those that are watching that aren't going to be able to stay for all the questions, these are your three codes. And yes, the video will be available here. And once again, in order to get the credit, here, you need to write down the three codes, go to gspt.org/attorney resources here and download the MCLE code sheet for MCLE credit for attorneys in California and for fiduciaries. Anyway, Paco, let's bring it home, man.
All right. So that was the last code, and then we have questions and answers.
Okay, now this is not a surprise for me, and I'm going to go ahead here and put my my image up here. I knew there were going to be tons of questions. We're going to work through this as best we can. Couple of things to remember. The reason that we invited Paco here is because of his involvement with the agency, and I think he just demonstrated really a unique knowledge from inside of the agency here, and explaining to us a little bit, one, about the law, but actually how the administrative agency deals with these things. I have one question, and then I'm going to just start through the questions and get through as many as I can. Paco, I've had a problem. On occasion, we may get a trust where the agency, you'll find this shocking, says, we'll come back and say that your trust is a resource, won't tell you what it is that they found. And then we always have the issue of trying to find an attorney who understands trust, who practices in front of Social Security. Where might we find somebody like that?
Well, thanks for setting me up for this. I do this type of work. I primarily do litigation at the district court level. That said, I can consult on cases at any level of appeal or initial reconsideration or initial consideration. I would say that probably I'm uniquely positioned to do both the litigation at the district court and to advise on trust, which means if you want me to take a look at a trust, I'm happy to do so and provide you my input as to why the agency likely made a denial finding or a finding that the trust didn't need an exception. Now, like I said, they're supposed to identify what part of the trust violated the policy and what policy it violated. So they're supposed to do that. And in theory, if the agency, let's say the regional trust leads, knew that a claims representative hadn't done that, then they would advise the claims representative to issue a new notice. We're going to have a hard time communicating with that regional trust leads because they don't have a method to allow for outside communications. If they did, they'd probably get an endless amount of messages asking what's going on with their review. They've been waiting forever. And so they don't really have a system in place for outside people like you and I now to ask them to fix something that a claims representative messed up. That said, if they become aware of it, they would have that claims representative issue a new notice. So the best bet you're probably going to have in that scenario is trying to ascertain what the problem was. Somebody like me could assist by looking at the trust, and sometimes it'll be somewhat obvious. Be able to say, okay, this is at least here and here. This is where they got you. Sometimes it's not going to be so obvious, and then you're going to do your best to one, appeal, and then when you appeal, hopefully then on reconsideration, they're going to reevaluate it, probably come to the same conclusion, but this time, hopefully the manual determination will include the information that they're supposed to include in the first determination.
Okay. And then the other thing is, and I'm going to make this a two-part question, and then we'll get to everybody else's question, but it's my show. I get to do it first. Here is, Paco, I probably have reported hundreds and hundreds, if not thousands of trusts to the Social Security. Not once have I gotten a letter saying, Steve, what a great job you guys did. I've accepted your trust, right? Now, this is going to be especially important for the 90-day review, right? So what if you don't get that magic letter that says, I've accepted your trust? What do we do at that point?
That's a good question, Steve. One, you do a great job on your trust, and so thumbs up there. But the question is, what when you don't know if your trust was approved, what do you do? And oftentimes the answer is not pretty because there's no good solution. I mean, it's a matter of communication, and unfortunately, right now, the agency is not doing a great job of that, especially during the pandemic. But generally speaking, getting a response from the person who's worked on and reviewed your trust is kind of what you need. And if they're not communicating, just trying to get a hold of somebody else, a supervisor, something like that's the only way you're going to find out. There's not right now a good way to communicate with the agency when they're not communicating with you. And I don't have any sort of special secret or anything like that. I do have a secret email address, but I can't give that out. It's super secret, top secret even. But you just have to maintain doing what most people do, which is talking to the representative they've been in communication with. When that doesn't work out, contacting that field office, trying to get a hold of the supervisor. Outside of that, there's kind of a wall right now, and there's not a good way to penetrate it in terms of information.
And keep in mind, and correct me if I'm wrong, Paco, but your primary involvement was with Region 9. You also did some work in Region 5, as I remember, but are there not 10 regions? I mean, each of them operate differently.
Yeah, that's right. So in terms of policy, I'm familiar with the different regions' policies because of the precedent opinions from the various OGC offices. But yeah, that's right. Every region operates a little bit differently in terms of how. So my experience primarily is with Region 9. I did do some work with Region 5. I was detailed there for about 18 months, but primarily my experience is with Region 9. So my take is based on my experience with Region 9. You might see a different outcome with your attempts to communicate with a regional office in a different region. I know some regional offices are much more communicative with the public. They're more communicative with pooled trusts and large trustees. So your experience might vary based on where you are in the country.
Okay, and there's a common theme throughout many of the questions here, and lots of questions about the payback. We'll do what we can, but about reporting trust. So like here's just a global question. And I'll give you my opinion too, but when is the best time to report a trust? And then just piggybacking on that, how about a third party trust? When is the best time to report that? And when do you have to?
So, I think that, I'm not somebody who deals with the initial application process in terms of, everything that's involved with the initial application, since I come in cases much later on. That said, it's my understanding that the agency would normally, when somebody is applying for SSI, they should be asking, do you have a trust? Are you a beneficiary of a trust? Even a residual beneficiary of a trust? At that point, they'd want to see it. Sometimes people say, well, yeah, I am. My great aunt Sue had something, but I don't know where that's at. And, I don't have access to that. And, the agency would maybe hold up your SSI until you get it once you reported it. So I think it's just important that as an individual, when you're mentioning a trust, if you're not actually a beneficiary of the trust, uh, and there's nothing to trigger that you'd actually receive a distribution or anything like that. I think that's different from being a current active beneficiary of a trust. That said, for completeness sake, if you have access to a trust, the information of a trust, like the trust agreement, then you can provide it and you're a residual beneficiary with no active interest. That's when you should provide it. You should identify it and explain it and provide a copy of it. If you think maybe you're a beneficiary of a trust, but you're not sure, I'd say find out before you start reporting the trust to the agency, because and make sure you can get a copy of it, because that might hold up your benefits, because they want to know what resources you have.
And I'll just add my 2 cents and then we'll plow through this. My feeling is, especially with the self-settled trust, but any trust that's funded, is I want to report it immediately, not just for the 90-day rule, which of course I'm concerned about the 90-day rule, but the other part of it is if there's a problem, let's figure it out now and not have it reviewed 5 or 10 years later, because then our overpayment's just going to be massive. So that's just my thinking.
I agree with you as well.
Yeah. So there we go. Okay. Going through the questions. Paulo's got a ton of them, which we can't go through them all, but is a trust language that does not allow government repayment after the beneficiary dies, or language stating that the trust will make no payments for obligations of a government agency, or exculpatory language? In other words, does it matter that the trust designates these criteria when it comes to SSI or Medi-Cal eligibility? I think there would be 2 ways of looking at this. One would be for the third-party trust, and one would be for the first-party trust. So do you have to have something in the trust that states that the trust will make no payments or obligations of a government agency? Is that required?
So, I mean, if I'm understanding the question correctly, because I have seen plenty of trusts which seem to have some holdover provision, maybe from, being drafted primarily by somebody who drafts third-party trusts, but then you see a special needs trust, and then you have language in it that maybe was intended to be a general trust provision, something about not making distributions for government assistance or making distributions to a government agency. You want to be very careful, because I have seen the inclination of personnel at the agency to read that language and say, well, over here they have Medicaid payback language, but over here they just said no payment to a government agency upon death or otherwise. So this is inconsistent Medicaid payback language. It doesn't meet the exception. I'm not sure what the advantage is, because maybe that's something to do with Medi-Cal or something that somebody would put in a trust. Don't pay anything to the government upon the beneficiary's death, or don't pay for any public. Obviously, don't pay. They want to not make payments to public assistance because they want to reserve or conserve the beneficiary's funds. But if that runs into the language for Medicaid payback, it's going to be a problem. It's a potential inconsistency that could make the trust, in a self-settled trust situation, not meet the exception 1917 D4A. Now, obviously, if you're in a third-party situation, it's just not going to be an issue, as long as the beneficiary doesn't have power to make distributions, doesn't have power to revoke the trust. It's just not going to be an issue as far as the agency is going to be concerned in a third-party trust situation.
And I think you mentioned this earlier. I think the rule of thumb is, in a first-party trust, less is more. In a third-party trust, you can go nuts. Okay, I mean, you can have multiple beneficiaries. You can turn it on. You can turn it off. You can do all these things. I think the only hazard is, and maybe you can comment on this, there's tons of information about self-settled trusts in the POMs. There's about that much about third-party trusts, and there's just not a whole lot of guidance there. So, I mean, that would be the wisdom. Here, what we do have a question about, is a special needs trust considered a resource? And I'll answer that. Not if it came out of my office, because we'd be out of business. But, key, a lot of what you talked about, Paco, kind of came down to not necessarily looking for magic language, but really the key concept of what is a resource, right? I mean, isn't that
Right.
what this all is?
Right, because somebody might call something a special needs trust, and it might be a third party trust, and that term of art, it's just not really defining what the issue is. The issue is who funded the trust, first of all, when the trust was funded, and then knowing what policy needs to be applied then. So, is a special needs trust a resource? Well, it depends. What kind of trust are you talking about? If you're talking about a third-party funded trust or a self-settled trust, if you're talking about a self-settled trust before or after it was established before or after January 1st, 2000, if you're talking about a self-settled trust established after January 1st, 2000, well, it's a special needs trust if it meets the requirements of 1917 D4A, and if it meets those requirements, is there a remainder beneficiaries so that the agency doesn't find that it's implicitly irrevocable. So ultimately, whether or not a special needs trust will be a resource will depend on a lot of factors that we just kind of covered here, but it all starts with who funded the trust.
Okay, here's one from our friend Avi Sachs, which also means this is a long one, but let's and hey Avi, here. Okay, so bear with me. If an initial notice that a trust is not in compliance fails to include all of the guidance provided by the trust review officer, such as a request for reconsideration must be filed, why would that not be a denial due to of due process? So then we go on further. It fails to provide meaningful notice, and 2, it fails to provide a beneficiary with an opportunity to mount a meaningful appeal upon the request for reconsideration stage. That is, the appeal at the stage is wasted on just obtaining the meaningful notice that should have been presented initially. Don't disagree with that. So instead of having an opportunity to provide a meaningful challenge at the request for reconsideration stage, the beneficiary is left to using that stage just to obtain information that should have been presented initially, thus depriving the beneficiary of an opportunity to have 3 stages of appeal in contradiction to all other appellants. Tackle that.
I understand the question. So I mean, I agree, right? So you're just going to appeal just to find out what they should have told you in the first place, and that violates your due process because then you kind of lose out on a level there of modifying your trust or achieving an understanding what the agency's saying, and that probably is a violation of due process, and potentially you jump the line and you go right to district court and you say the agency's violated my due process rights. And I demand satisfaction, and perhaps you win that case. Perhaps, not a lot of people are going to do that. The agency, I think, in practice, it's a large, bureaucracy, right? So in practice, the claims reps are doing these things by mistake. They're not following policy. So the policy would provide for the due process. The manual determination would need to identify the problematic language, the things to fix. When there's a violation of due process in practice because somebody wasn't doing what they're supposed to, there's not a good method within that I know, and maybe you know something else, Avi, there's not a good method for fixing it outside of the just appealing it and or maybe bringing action to the district court. There's just not a method. Even for me, when I worked at the agency, if I found a problem with something and a claims representative, how he did that, I'd have to, send it through the channels. It'd be a process just to get a new manual determination sent out. It's not easy when you work in the agency to fix a problem like that. It's definitely going to be hard outside the agency. And so if you have a situation where you feel like your due process rights are violated, one, you just have to appeal it up, I would advise. otherwise, and then appeal it up to district court and explain to the court how your due process rights were violated. And probably the court will take that into consideration in issuing an order, whether it's dealing with an overpayment or whether a finding as to whether or not the trust met the requirements for a resource exception. So I think, litigation is probably one of the few methods we have on this side of the agency, outside the agency, for dealing with actions that don't comply with even agency standards that violate due process. You litigate it, you let the court see what's going on. And especially in California, I mean, I like the courts over here. I think they do a really good job of that in recognizing problems in the process. You point it out to them, and usually, you can get something out of that court process. So I would say appeal. That's why appealing is important, and is keep appealing.
And part of the appealing resolves the issue here for that specific case. But the other thing is it does provide guidance and eventually will change how the Social Security Administration does things. So, I mean, it's important on an advocacy level too. It's also important to be able to have folks that can actually represent you, and you and Avi are kind of on a short list here for that sort of thing. So here we've got two questions that kind of come together. One's from Teresa, one's from Connie, just to let you know. These both have to do with houses in revocable trusts, okay? So let me start off with Teresa's. And I actually had a case in Berkeley where I have to tell you, I swear to God, I just wanted to bash my head against the wall because it was just, we had a beneficiary that put his house in a living trust. And in California, you especially want to put your house in a living trust because it avoids the Medicaid payback and in probate and all that other stuff that many of us that are estate planning attorneys out here rely on here. But one is, what if we have a living trust and the principal asset, let's say the only asset in the trust, is the residence the beneficiary lives in? Do we got a problem? I mean, because it's not a special needs trust. We're looking.
Well, I've seen this a lot, and then you're dealing with basically two situations. One, maybe the trust. Okay, so let's say it's your house, and you own it, and then you draft a trust and you stick your house into it. So it's a self-settled trust. And then it's your primary place of, your primary residence. So in that situation, unless the trust meets the exception of resource counting, the trust is accountable. The trust is, I want to say the trust is accountable resource, but that doesn't mean every asset or thing being held in the trust is accountable resource. So if I was at the agency and I saw this scenario, I would advise that while the trust does not meet an exception to resource counting, and the assets in the trust would otherwise be accountable resource, the house in this situation is not accountable resource because it is an excluded resource. So it's your house, your principal place of business, and you live there. Your principal place of residence. So it meets a resource exclusion, even though it's being held in a trust that would otherwise have the assets of the trust being accountable resource. Now, if it was cash, it would be accountable resource.
So let me just follow up with a boneheaded question. Okay, let's say we have a beneficiary who's fully competent, trustee, and let's say it's a self-settled trust, purchases a residence, an exempt resource, like a pair of socks, right? So first, step number one, we buy the house and put the house in the beneficiary's name, no trust. Do we have a problem?
I deal mainly with trust when I was there, but I don't think so, unless you're trapping me here.
No.
I don't think so. I think that would be an excluded resource.
I'll even go one step further. Tom's recently said we don't have a problem with that it's an exempt resource. Step number two, you take the house and put it in a revocable living trust, which is an exempt resource.
Right.
Now, do we have a problem?
I'm saying we don't have a problem.
Right. Unless we have an eligibility worker. And by the way, this isn't to pick on the eligibility workers. They deal with a lot of things and they go to the POMS for guidance. And you know.
Yeah, I mean, yeah, because then they're kind of looking at it, but they're looking at it right. They're not carrying it over, right? They're just saying, oh, everything in the trust must be accountable resource. Well, no, I mean, resource exclusions still apply to assets that are held in a trust the same way they'd apply if you held them in your hand. Like this is whether it's in the trust is all passed through. So as far as the agency is concerned, if it's a resource in the trust, but the trust is accountable resource, and the resource in the trust is going to be accountable to you. But if the resource in the trust is an excluded resource, it's going to be excluded to you still. So just because an excluded trust is placed into a resource doesn't make it all of a sudden. I'm sorry, just because an excluded resource is placed in the trust doesn't mean the resource is no longer excluded.
Yeah. So let's take this one step further, and then we'll get to Connie's thing. You put the house in the trust, excluded resource, so far so good. Okay. Now you take that same living trust and somebody gives you $3,000 in cash, and you put the $3,000 in cash in the living trust. Do we have a problem?
Yeah, right. So that the $3,000 cash being the accountable resource, because the trust doesn't meet an exception to resource counting, self-settled trust established after January 1st, 2000 doesn't meet an exception to resource counting, so that the assets in the trust would be accountable resource unless they're excluded resources like the house would be, but not the cash.
Okay, and let's go to Connie's twist. Let's say instead, Paco, this won't surprise you, but housing is probably the biggest issue we deal with folks with disabilities, and it's probably the biggest issue we deal with folks that don't have disabilities. Here, let's say instead, what we do is we have the parents buy a house, go and get a third-party revocable trust, okay? Put the house in the third-party revocable trust where the parents are the trustees, and of course the beneficiary has no control. Is the fact that that trust revocable, is that an issue? And by the way, a little clue, it's only revocable to the grantors,
Right,
not the beneficiary.
So no, I mean, exactly. A trust can be revocable so long as the beneficiary is the one who can't revoke it. So we look at we look at the powers of the beneficiary. Does the beneficiary have access to the money to distribute the money or resources? Do they have power to sell the money or resources in the trust? Do they have power to revoke or terminate the trust? We don't care if a third party does, as long as the beneficiary does not.
Okay. And by the way, for those of you that are watching, I'm planning on going maybe for another 7 or 8 minutes. We are officially over. If you have other things to do, and you can certainly watch the video later. But here John Kirk has a kind of a compound question, but I think I can break that all down here into something. In his situation, as he's described it, he's in a situation like a lot of military families where they've been able to set up and there was a change where you can take your military pension and leave it to a self-settled trust. That's not really the core of the question. Let's say you've got that all set up, everything's okie dokie in a first party trust, but what you really want to do is avoid that payback. The question is, now, can you from the first party trust start making transfers? And this is going to be a two-part question. So the first part is, could you just start making transfers to the third party trust and just kind of avoid the payback altogether?
So I'm sorry, I don't think I understand the question fully.
So let's say you have a payback trust. Can you start making transfers from a payback trust to a third party trust and avoid the payback?
So kind of to liquidate the trust through distributions prior to the payback?
Yeah.
And this would be prior to the beneficiary's death or early termination of the trust?
Yep.
Well, I mean, this is one of those situations where, you get into what's permissible through practice versus what's permissible in the face of the document. So, I mean, the agency definitely wouldn't be okay with that, but, especially because you're doing it just to avoid payback. But none of this might be in violation of the wording of the trust agreement, perhaps. But this is the exact type of thing the agency would say is a violation of practice. And if they find out you're doing it, then they'd say this is, a violation of Medicaid payback.
Part two, and by the way, I may know this better than you. What if they start making transfers to an ABLE account? Okay, and let's say it's a CalAble account where it's not subject to payback. Do we have a problem there? And
I don't know enough about CalAble,
and that's what I'm gonna come in, is that it's very clear that you can make a transfer from a self-settled trust, any special needs trust, into an ABLE account. Of course, you can only do 15,000 a year, and that's not a disqualifying transfer. And if you go to our website on ABLE accounts, has lots about that. Okay, just chugging off on a couple of things. Oh, well, here's a common one, and maybe this is good advice. Funeral expenses, right? And we'll make this twofold. Now, in California, the way it is now, our Medicaid agency actually allows you to pay for reasonable burial expenses. Although, Paco, what if we write in our trust, because we're from California, that we can pay very reasonable burial expenses before the payback? What's the result going to be?
Well, Steve, that is precisely what happens about, at least 30% of the time. So the trust language would, follow state Medicaid rules or state Medi-Cal rules and allow for funeral expenses as a permissible administrative expense prior to Medicaid payback. And the agency it's just a no-brainer for them. They're going to say funeral expense, not permissible. Trust violates the exception to resource counting.
And the fact that we do it all the time, is it? I mean,
right. I mean, it just makes them more aware of it because they're more tending to look out for it because they know it's a common problem.
Yeah, and by the way, it's I think there's a lot of confusion with this often because the payback is actually the state's issue. It's not SSI's, Social Security's issue. The Social Security, they're reviewing this to make sure it's compliant with the D4A or D4C laws. That's the reality of the situation doesn't really have much to do with it, right? So maybe your state is looser on it. Good for you. Okay. Here, another one, but following up, funeral expenses. What if the trust pays for a prepaid burial plan? Do we have a problem there?
Well, the prepaid burial expense, if it's okay, so yes. Short answer is yes. You could potentially have a problem there, even though technically prepaid burial expenses could be excluded as resources in some scenarios. That's not going to help you out when the whole trust is found to violate the exception to resource counting. So all the other assets in the trust are then become accountable resource, even if the prepaid burial expenses are not. So it would be better not to provide for that. In practice, I don't see a problem necessarily if, as part of what the trustee is, within the broad parameters of special needs, provides a payment for the interests of the beneficiary to prepay some burial expenses because it's for the beneficiary. It's where he's spending his afterlife, after all. But if you have it in the wording of the trust to be paid, it could, and I'm just saying that, yes, there's a way to argue why this would not violate, because it's a lifetime expense as opposed to expense upon the termination of the trust. But if you want to avoid the agency finding your trust as a resource, I wouldn't have it in there. And then, if it's actually paid in practice as part of the broad expenses, that's okay. But I wouldn't put it in the language of the trust if you want to get your trust approved.
We're coming back to first party trusts and what we should put in the trust and not put in the trust.
Yeah.
In the early days, well beyond me, I did not invent the special needs trust here. There's a lot of folks who were there before that, but it was traditional. They would put in the laundry list, right? So a special needs is, and then it would go on for 1,000 different things. I think most of us have learned that laundry lists are bad You don't have to list every expenditure. And in fact, if you do, you're just putting a target on your back because, hey, interpretations of these things change all the time. Here, so it may be one of those things where you don't really have to include every possible expenditure that comes up. You basically need to stick to basics, right? Because
Yeah,
I know
I
for us,
agree.
we really urge folks to get Medicaid compliant prepaid burial contracts, even though California currently allows you to pay reasonable burial expenses, because that's just an interpretation by the agency, and that could change tomorrow. You just never know what's going to happen.
The more situations you create in a trust by putting things in there the agency's never seen before, the more likelihood they're going to find it to be problematic because they might not understand it. They might not understand what the language is really providing for, and then that might result in them interpreting it as violating one policy or another. Simplify the trust and self-settled trust situation. Anytime you want the exceptions to resource accounting to apply, simplify the trust. As you mentioned, I think if it's a third-party trust, it's not going to be as much of an issue. But anytime it's a self-settled trust, you're trying to have an exception apply, simplify the trust.
Okay. We have another question here of somebody who has been waiting for a response about whether or not the trust is a valid trust or not from the agency for 6 months. What do you do? Well, that's a good question. What do you do?
Well, I would say only 6 months. Well,
Yeah,
that's not bad. Well, here's the situation. If under the new, I don't know where this individual who's asking from is located, but let's say it's Region 9. That could be for many reasons. So I don't know, but it could be a development issue. So maybe it went up the chain for an OGC opinion, but then OGC kicked it back saying we need more information in this regard. And the claims representative got too busy doing other things and hasn't reached out to you for that information. And at the same time, isn't issuing a determination because they haven't gotten an OGC opinion. If you're in a different part of the country, it's quite possible that that opinion went up the chain and the regional trust lead didn't know what to do with it, and they submitted it to OGC for an opinion. Now, OGC might, doing a formal opinion, they might be on it for 6 months or more. So it just kind of depends on the situation. And the truth is, you're probably not going to know, and it's probably going to be almost impossible to find out unless the claims representative you're dealing with is going to volunteer that information. Sometimes if it's pending legal opinion, they might tell you it's pending legal opinion, but sometimes they won't.
Okay. And I'm sorry for a lot of folks that are following this. Oh, actually, Amy had a question here, but we're going to have to bring this to a close pretty quick here. Basically for third-party trusts, once again, when are those supposed to go under review here? And I think you did kind of cover this. When does that go under review, and when should you report it? And I think you did cover that before.
Well, yeah, as you indicated, giving information is typically a good thing. You want to give information, but if you don't even know if you're a beneficiary of a trust, or you think you heard once that you were, you should really find out. Either way, and then find out before you start claiming to be a beneficiary of a trust. Make sure you are one, and are you an active beneficiary or residual beneficiary? If you're either one and you tell the agency you have a trust, they're probably going to want to see the trust, which means, do you have access to getting a copy of that trust? And if you don't have access, that could be a problem, because let's say you're eligible for SSI, but it's held up based on resources because the agency wants to see the trust before they approve. But you don't have any access to that trust. Your great aunt made the trust, and your far, far cousin away has the trust document and you really don't have any way of getting it, that's obviously going to be problematic for you. So in those situations, I'd probably consult with somebody first before, you make a decision as to whether or not to disclose the trust, because, um, obviously, if you're a beneficiary of a trust, that's kind of a different situation, but where you might not be and you might not have access to the trust document, that's kind of a different situation.
Okay, so last two questions. This next and last one is from my friend Pat Tobin here. And so let's toss you a hardball, dude. When a special needs trust is deemed to be countable, if the trustee decants or otherwise transfers the funds into a pooled trust, does that prove that the special needs trust was an available resource? And so there is no defense to the claim that the S&T was an available resource until the pooled trust is funded. Is there any other concerns about such actions? I mean, that's the new hot topic, is decanting.
I don't know the state law on this, why that would be an admission. I think as far as the agency is concerned, in my knowledge, there's nothing wrong with modifying a trust to comply with agency rules or transferring the trust to another trust that meets the agency's rules. It's not an admission necessarily. If you want to maintain your appeal after you do that, so let's say the agency finds trust one as a resource. So you go ahead and in seeking reconsideration, in the meantime, you transfer the assets from trust one into trust two. Are you admitting that trust one was a resource and you can't maintain your appeal? No, absolutely not. I mean, trust two might comply and the agency will then find that the assets are not a resource. And they might not pay you, they might not get rid of that overpayment for what you owe from when the assets were in trust one, but you can still appeal and say, I believe trust one wasn't a resource, but I mean, at the same time, I wanted to get SSI, so I moved the trust while I maintained my appeal. I mean, I moved the trust assets into what the agency would count as a qualified trust while I maintained the appeal. So, not to my knowledge, but maybe there's something you guys are thinking of that I'm not aware of, where the old apologize rule in torts class, where they say never apologize, because when you apologize, you admit you did the tort. Not that I know of here, that you, by moving the trust assets, you'd be admitting that the trust is a resource.
And I think this is where having knowledgeable counsel who practices in front of Social Security can be so important. And one of the reasons I was just so excited when you reached out to me. So here's our last question. And I want to apologize. Apparently, we probably could have competed with Abram Sachs's 3.5 hour record, but we actually all have to go back to work here. So I'm going to end this with Heather's question here, which is, do you only deal with issues regarding trusts as a resource, or do you also deal with issues where they are reducing ISM without justification? Now, maybe I can expand that a little bit, because I will tell you, and I think the first time that you contacted me, I was so happy to run into you, because trying to find knowledgeable counsel that practices in front of Social Security and understands trust is so difficult. So, Paco, just ending this here, as far as representing attorneys, fiduciaries, families with their trust matters, what kind of things are you able to represent them on, and what are you not?
Okay, yeah, thanks for asking, Steve. So it's important for me to explain what I know and what I don't know. So what I know is what I practiced in heavily while I was with the agency, and what I've done since. And that's primarily involving whether or not a trust is a resource, which means that's where most of my experience is. Whether or not certain distributions from the trust or in-kind support, different things, are countable income, I didn't have to deal with it as much, because the agency folks would take the resource determination advice and then plugging it into the POMs, make those kind of decisions. So to be honest with you, accountable income is not my strong area, but if, because district court litigation is, you have an appeal that goes up to district court, you're in California, you want representation. I do have experience plenty with disability and other issue litigation in the district court against the agency who can assist you. I mean, which is to say, I'm not an expert on that, but I become an expert on a case-by-case basis because I'll put the time into researching it and see how it applies in your scenario. I mean, having the background on the trust stuff helps, gives me a good starting point for some of this in-kind support stuff. But I'd say in the past, I haven't dealt with it to any great degree. I know the basics, but in any case, every situation is a little bit different. So researching specific issues is probably a good idea for any attorney. So
I was just going to say, having folks like you and Avram who actually practice in front of Social Security, we do not here, is just so astounding here, because there's very few practitioners who do that. And the other thing that you actually do at the law offices, Francesco Benavides, here is, what else do you do, dude?
So, primarily a big part of my practice is litigation in the district courts for disability appeals. So, determinations that somebody is not disabled, appealing those denials up the chain through the appeals council level. So usually I take on after the appeals council denial, after the ALJ decision, unfavorable decision, and I handle the district court appeal at that point. So the district court is more of an appellate appeal at that point, because we're looking at the evidence that's already in the record and making legal arguments and briefing. So there's not really a development of evidence at that point. It's more of articulation of the analysis of the law. So, district court appeal of disability cases is my primary, one of my primary areas of practice.
Okay, as much fun as this has been, it's time to call it a day. Paco, I just want to thank you so much for sharing your knowledge and your experience here, which is so valuable about, not just going through the rules, but what is the agency's thinking with that, which is, so helpful for those of us that, draft trust, administer trusts, and all of that, to really get some knowledge about the inside thinking about how this all works. Anyway.
Well, thanks for having me. I appreciate it.
Yes. So anyway, for the rest of you, thank you very much. We will have this up on the internet soon. For those of you that are interested, we are working on our 2021 set of MCLE classes. And one way to get on our list is either go to gspt.org and go to attorney resources and sign up there, or you can email amy@gspt.org. That's AMY@gspt.org. I want to thank everyone for attending today. Paco, I want to thank you so much. And we're getting lots of comments about how helpful this has been. No, we didn't answer all questions. That would take days here. But I want to thank you so much, and happy advocating, and goodbye.
Thank you.